room today. I was able to kind of rally and do it. Hi, Chinga. Welcome to the stage. Anybody
Hello.
else who wants to come up, just raise your hand and I'll bring you up.
I don't know why you guys go in those rooms. It's not fun to talk to stupid people.
It is not. It really is not. I was just there because John and other people were there, but then I'm like, why are they here? But then I kind of got sucked in. All right. The slides for today's talk are, as usual, linked at the top. And are we on YouTube yet?
Yes, sir. We're streaming.
Okay,
I'll
good.
paste the link in a bit.
Okay, very good. Thank you very much. And so last time in the discussion of IP law, we talked about Section 101, which we said was the gatekeeper section in patent laws. It defines what the patentable subject matter is. And so Section 101 determines whether you are patent eligible or not, and then the other sections of the Patent Act determine whether you are patentable or not. So today we're going to discuss the first section of the first law, the first statute that we run into, Section 102, that deals with novelty. Just a little point. Last time when we discussed at the end of Section 101, I said that the next session I'm going to talk about the cases of Alice and Mayo Clinic. But the more I thought about it, the more I realized that that was way too much into the weeds for a general conversation like we're having now. And so personally, I was kind of satisfied with what we did under Section 101. But if anybody else wants to discuss those two cases, we can certainly do that at the end of the talk. So as I said, slides are linked to the top, and slide numbers refer to the position of the slides in the deck. So slide 1 is the introduction. And again, kind of like the other two times on slide 2, I'm going to start with vocabulary. What does novelty mean? Novelty means that novelty requirement, the invention has to be new. And so there's today and the next session, we're going to talk about what does new mean. It has a legal definition. What is the invention? The invention is the subject matter in the claims of a patent or patent application. We talked about that also a couple of times ago, that the claims of a patent determine the metes and bounds of the invention. And so when we say the invention, we talk about the subject matter of the pending claims. Prior art, again, is a disclosure before a certain date. Now that date could be whatever date, and we'll run into that, but usually the filing date or the effective filing date of the patent application. And what is a disclosure? Disclosure is a publication, a product out in the market, a talk, a lecture, a conversation, performing a method, etc. Those are all considered disclosures because you are disclosing the subject matter of what is your invention to someone else. Now, we talk about prior art and a disclosure and all that. Well, what are the requirements for that disclosure? So on slide 3, I'm showing you a whole bunch of disclosures that we've had through the second half of the 20th century. So top left, flat screen TV. Top middle, touchless diagnosis device. Top right, Google Glasses or Meta Glasses. Bottom left, Bluetooth. Bottom middle, tablets, iPad, etc. And bottom right is actually knocks you in the head that you have a communicator device and a Motorola flip phone that shows those. So is Captain Picard holding that tablet? Is that novelty defeating prior art against Microsoft's iPad? Microsoft Surface or Apple's iPad? And the answer is no, right? Even though it is disclosed here, that is not going to be a novelty defeating prior art. The flat screen TV that we see in the original Star Trek series is not novelty defeating for our LCD displays today. Why is it? Because as we see on slide 4, the disclosure has to be enabling. Enabling means it has to allow somebody to do something. What is it that it has to allow it to do? We're going to see enabling disclosure in 2 different contexts. One is in the context of patentability. Section 112, we're going to get to in a few weeks. And that is, it says that, have you disclosed the details of your invention sufficiently in your patent application that would allow one of ordinary skill in the art to make and use the invention? Both of those are important. The ordinary artisan has to be able to both make the invention and use the invention. A prior art disclosure also has to be enabling, but it has to only enable someone to make the invention. So even though Captain Picard is holding an iPad or Lieutenant Uhura is having a Bluetooth in her ear, those are not enabling, because by looking at that, we don't figure out how to make those things.
Does
So
the
those
same
are
thing
not.
apply to the flying saucer and the electric lamp that we see in Egyptian hieroglyphs?
Yes, absolutely. Absolutely. In fact, the electric lamp in Egyptian hieroglyphs was a question on my patent law final in law school.
Oh, really?
Yes,
No
that
way.
it was like the archaeologist finds the disclosure of an electric lamp, and then the answer was no, it's not an enabling prior art disclosure. So yeah, that's funny that you said that. Okay, so with all of that kind of vocabulary or background, we're now ready to tackle section 102. So on slide 5, we have the text of section 102A. Section 102 has 102A and 102B. Each one of those has sections 1 and section 2. A says what novelty defeating prior art is. B says these are the exceptions to what we're talking about. So we'll talk about B much later. First, A. Now, the preamble of this section says a person shall be entitled to a patent unless. Anybody on the stage wants to hazard a guess why that sentence is important? A person shall be entitled to a patent unless.
Because there's some cases where a person will not be entitled to have a patent.
No. So
there are certain obligations which he has to follow for regulations and the policy.
the other way around. Okay, so this means you're going to get a patent unless you don't do these things, meaning that the burden of proving that you have or have not met all the legal requirements is not with the applicant, but it's with the patent office, because the starting position is that you're going to get a patent, except if you don't do these things. So the office has to tell you you haven't done these things. So the functional result of that is that when you file a patent application, you're telling the patent office that this patent application is patentable. And now the office has to, through rejections, tell you why it's not. And then again, you don't prove that your invention is patentable. You prove that the examiner has not shown that the invention is not patentable. I think everybody got lost into all the nots and no's and all that. But the thing is that if the invention is patentable, unless the examiner says it's not, if you prove that the examiner hasn't successfully said that it's not, then it goes back to being patentable, even though it might be unpatentable for reasons that the examiner is not aware of. And we get to the rebuttable assumption of validity later. So Section 102 basically sets the stage that the first condition that the office has to show that the invention is not patentable is that the claimed invention was patented, comma, described in a printed publication, comma, or in public use, comma, on sale, comma, or otherwise available to the public before the effective filing date of the claimed invention. I set those commas on purpose because each one of those is a requirement of the law. I'm going to first talk a little bit about the effective filing date of the claimed invention. What does the effective filing date mean? So when you file your application, it gets a filing date. That's the date that the office received your patent application. But your application can claim priority to a previously filed application. And if it does that, then the effective filing date of the application will be the filing date of the parent application, the one that you claimed priority to. So let's go to slide 6. This is from last time or the time before when we were talking about why is it that we have provisional applications in the United States, and we said this is so that foreign applicants and U.S. applicants are on the same footing before the U.S. Patent Office. And this is the thing: the provisional filing date now becomes your effective filing date for prior art determinations. So the effective filing date under Section 102 is this filing date of the prior application, the provisional application. So for Section 102 calculations, meaning trying to figure out if a reference that we're looking at was published before our filing date or not, we look at the filing date of the prior application. So this is why the foreign applicants had a leg up, because their priority went 1 year before the U.S. applicants. Now, with provisional, the effective filing date under 102 for both U.S. applicants and foreign applicants is going to be the same. Any questions on that before I continue? I know this is a This might be a complicated topic, but hopefully we can follow. So I guess let me check the chat. No. Okay, so slide 7, I'm going to now parse out the section 102. They claim the invention was patented. Well, that's pretty understandable what it means. It means that the claims of the patent, it's disclosed in a patent, described in a printed publication. So now the question is, what is a printed publication? Obviously, if you publish it in a newspaper, that's a printed publication. If you publish it in a trade journal, in a scientific journal, if you put it on your website, we all know that that's a printed publication. So we're not really worried about the obvious meanings of these terms. That's not where disputes happen. The disputes happen where you have to actually make a judgment as to, is this a printed publication or not? And on slide 8, we In re Klopfenstein by decision 2004 by the Court of Appeals for the Federal Circuit. This case is about that Klopfenstein had filed a patent application, but then it turns out that the subject matter of the patent application was the subject matter of a poster that Klopfenstein had presented in a scientific meeting. The poster was up. I mean, John and Shamesh and Chinga probably know what I'm talking about. The poster goes up, and it's up for a couple of days, and then they take it down. In chemistry meetings, the poster goes up for like 4 hours or so. That's what the length of the session is, and then comes back down. And what is a poster? How does it go up? How does it come down? The slide 9, that's one of my wife's research students who is presenting the results of her research at an American Chemical Society meeting. So that is the poster. The poster has, introduction and then method. It's kind of it looks like a short paper. It has methods, results, discussions, conclusions, things like that. But as you see, it's pretty short and sweet. So Klopfenstein had done something like this, and now the question was, well, is this a printed publication? Because it was not published, it was not disseminated. It was printed, but it wasn't. What was it published? Published means that it is disseminated to a wider audience. If a publication is not disseminated, then it's a print. If it's disseminated, then it's a publication. So what does the court say? Indeed, this is slide 10. Indeed, the key inquiry is whether or not a reference has been made publicly accessible. The statutory phrase printed publication is interpreted to mean sufficiently accessible to the public interested in the art. Dissemination and public accessibility are the keys to the legal determination whether it was published. So the printed publication bar is grounded on the principle that once an invention is in the public domain, it is no longer patentable by anyone. So how do we figure out this? What if my poster was up for half an hour instead of 2 days? What if it was up for 30 seconds? Would that still be printed publication. The exact same poster, the exact same location, the exact same audience, but it's up for only 30 seconds and then comes back down.
So Sam, oftentimes a poster session there'll be an actual published meeting, right? In the publications of the meeting, we'll talk about the poster session, and each poster may be briefly described, may not. I mean, sometimes they are, sometimes they aren't. But that's not what you're talking about here. And in this case, it was just a poster that was put up during the meeting and not actually attached to a,
Yeah. So before the meeting, about like 2 or 3 weeks before the meeting, the abstracts get published.
Yeah.
And posters also have abstracts.
Right.
Under 250 words. And so that gets published. That itself is also a public disclosure. The issue here was that the relevant information was not in the published abstract, but was in the posted poster. So the abstract was not prior because it didn't have those details, but the poster was. Does that make sense?
Yeah. Well, I was just wondering because you hadn't mentioned the meeting bulletin or whatever that would be there as well for participants at least.
Last
But that
time,
wasn't relevant.
last time I participated in one of those, and by the way, I really hate participating in one of those for some reason. It's a big waste of time. Last time they made us present a public talk, a poster, and send them a manuscript that is supposed to be the content of the thing. And so I'm guessing this is a result of what you're about to tell us.
No, that is idiosyncrasies of the particular discipline. So, for example,
that could be the case as well. Yeah, no, I take it back actually.
I have a cousin who's a pretty famous art historian, and when she needs to publish her things, she actually has to go to a conference and read the paper that she's about to publish. They won't accept the papers unless it is read verbatim. Just, I've been to a couple of her talks, and she just stands there with the copy of the paper and reads them. And so that's one of the requirements of art history. In chemistry, no, you don't have that requirement. So on slide 11, the court tries to answer the question of, well, would 30 seconds be sufficient or not? And so you said, we have to look at some factors. The length of time the display was exhibited, the expertise of the target audience, the reasonable expectation or lack thereof that the material displayed would not be copied, and the simplicity or ease with which the material displayed could have been copied. This case is before iPhones, but it's not before digital cameras. And I don't know about John or Shamash, but when I go to these scientific things, the posters that I like, I don't take notes. I just take a picture of the poster, and then I come home and deal with it then. So in this area, because the display was exhibited for 2 days, because the target audience was extremely expert in the area, they're all scientists working in this area, there was no reasonable expectation that nothing would be copied. In fact, when you go to the poster session, you're hoping people would copy your poster because that means they're actually interested in what you're doing. And the simplicity or ease, you can just take a picture of it. So the court says when we look at all of these relevant factors, we conclude that Klopfenstein had publicly disclosed his invention when as in publicly disclosed in a printed publication when he displayed his poster. Does that result make sense to people on the stage? Is it too harsh? Is it
No,
just
I
right?
think that's fair. I mean, yeah, he should have published anyway, like in a journal, but yeah, that's equally boring, to be honest. So yeah, I think that's fair.
Yeah. So because of cases like this, when our scientists want to go to a meeting, before they submit the abstract, we file a provisional patent application so that we don't run into this stuff. And basically, I would say all patent attorneys kind of do that nowadays. I mean, cases like Klopfenstein are not rare. They do come up from time to time. So if there's no questions on printed publications, we go to the other element of publication, and that's public use. What does public use mean? So if I invent a new dingus for my car, and then I attach it to my car and I drive down the freeway, we all agree that's public use, or anything else that we're basically seeing people use when we're walking down the street. Everybody agrees that that's public use. So that is not where litigation takes place. Where does litigation take place? It's where, again, it's not clear. You can make a case either way, whether it was public use or not. I'm going to briefly talk about two of these cases. One is Baxter International versus Kobe Laboratories, a 1996 case. So the NIH, some guy at the NIH, that National Institutes of Health, the NIH, the guy invented a new centrifuge, and it was this happened in the 80s, and it was a great centrifuge, and he's proud of it and all that, and it's in his lab, spinning around doing its centrifugey things. So I don't know if you guys have been to NIH in Bethesda or not, but you can't just walk in to the NIH, right? You there's like security. You have to get past the doors. You have to have somebody escort you. I mean, all the stuff we talked about, trade secrets, right? And this centrifuge was in this guy's lab. The only way you would see it is if you could get past the security, go into his lab, and look at the centrifuge in the corner. The court says this was public use. Why? Because it was being used in the normal way that it gets used, and no special step was taken to shield that from the prying eyes of others. So because it was in the normal course of its use, even though that normal course of use was not open to the public at large, it was open to the public that had access to it. And so it was public use. The very first case in this area is Egbert v. Lippmann. Egbert is taught to all law students. who take IP, because it is something that not very intuitively obvious. So at the time, in the late 19th century, the springs in women's corsets were made out of whalebone. And because it is hard, but it also has some give. Egbert is the first one who makes one of those out of steel, and it is a lot more springy, a lot less uncomfortable, and a lot more cost-effective than the whalebone one. He makes one of these corsets for his wife, and one for, I think, his sister or mother-in-law or somebody like that. And the two wear them as they go about their business, and they're like, oh my God, this is the greatest thing. And so he then tries to mass produce them and tries to patent them, but it ends up being that, no, that was public use. And it's like, what? In the 1880s, who is going to see the corset of a woman walking down the street? And who is going to see the spring in that corset to know of what material it was made? No one would see that. The only people who would know about this are the people who are wearing it and Egbert, who made it. But the court says, nope, such use is public, even though the use and knowledge of the use may be confined to one person. Why? Because the donee or vendee without limitation or restriction or injunction of secrecy, right? It was used by those without telling them that this should be a secret. And so they used the corset in the normal course of use of a corset in public, therefore it was a public use. There's an exception to public use, and that's experimental use. There is the case, I forget the plaintiff, the defendant is City of Elizabeth, New Jersey. I know that because my in-laws used to live there, and so it's like, City of Elizabeth. But the guy was coming up with a new formulation for asphalt, and he had to test whether the asphalt can withstand the weight of the traffic or if it's going to fall apart. So what he did was that he took permission from the city and paved a short portion of one of the roads with his asphalt. And then he basically would visit it every day and would take notes and would take data. How is it functioning? And he did that for about 2 or 3 months and then went back and revised his asphalt formula based on that and then applied for a patent. And so they said, look, you used it in public, but the thing is, no, this is experimental use exception. Experimental use exception means that the only way you can test your invention to see if it's working or not is to do it in public. You cannot, in a laboratory, figure out how asphalt is going to behave under normal traffic conditions. The only way you can tell that is by putting it under normal traffic conditions. This concept of experimental use exception is quite alive and well. One of the other kind of 2000s version of that is Easy Docks, where the people make a plastic dock that was modular for properties at the site of, on the banks of Mississippi River. And so the thing is that these are inexpensive and easy to to construct. You just, kind of like Legos, you attach them together and here's your dock. And the only way they could figure out whether they could stand the weather conditions and use conditions and boats running into them, etc., was to put one of those in front of an establishment and have it used. The experimental use exception, you really, really have to show that this is experimental, meaning that you have to show you were visiting it on a daily basis, you were taking data, you were analyzing that data, and if you can show that, then you revise the invention based on the results that you got out of that public use, then you basically have a solid case for experimental use exception. Yes, John?
It seems like there would be a provision for people to say, hey, look, I'm going to do some experiments in public and kind of put the patent office on notice or something.
No, because most of the time, these issues don't come up during the patent prosecution. A lot of times you disclose these things to the patent office, but the patent office doesn't really pursue it. A lot of these things happen during litigation. That's when.
But still, I guess I don't, why shouldn't there be? Would there be a problem with having a procedure just to head off things like that, to say, look, I put you on notice that I was going to be experimenting with this in public?
And the thing is, whether the public has notice or not is not important. What's important is what was your behavior during the experimental use. And whether you have put the public in notice or not is not going to affect how your behavior during the experimental use.
Okay, that's fair. I get that.
Yeah. Any other questions? Anybody in the chat? Okay.
So, if I can just chime in, the intellectual property rights are how different as opposed to law?
Law is how intellectual property rights are recognized. Right? I mean, unless there's a statute that says this is how you have a property right, it's not clear whether you have property right or not.
So under the US patent law, are there rights listed in the document, or there is a law directly that is applicable?
So, the rights that patents give you is the exclusive rights. Those are basically under infringement. So yes, Section 271A says that you can exclude others. You have the right to exclude others from making, using, selling, offering to sell, or importing into the United States the patented invention. So that is kind of the total right that you have, which basically is the same as any other property right. And so then after that, how that bundle of rights is distributed is done basically by common law through court decisions. Does that make sense?
Yeah, thank you. Thank you so much for that. Yeah.
Sure, no problem. Any other questions? All right. So we go to slide 14, And this is on sale bar. Sorry. This is the last topic I'm going to talk about today. And so we're going to spend a few weeks here on section 102. I don't want to go too fast, so we're going to stop it here on sale bar. What is on sale bar? Well, if you start selling your invention and then you try to patent it, the law says no, you can't do that. In the United States, we'll see when we talk about 102B, there's a 1-year grace period for all of these, right? So it's like you can start selling it, but the day you start selling it, you have 1 year to file your patent application. But we're not going to talk about that grace period. We're just going to talk about, well, what is an on sale bar? Although, sorry, we will talk about that grace period. Just anyway, the controlling case in this area is Pfaff v. Wells Electronics, Supreme Court case 1998 by Justice John Paul Stevens. Unanimous decision in Pfaff. When it came out, it blew us all out of the water because it expanded the universe of on sale bar. So what are the facts? The facts of the case are on slide 16. November of 1980, Pfaff begins to work on drawings for some doohickey. And then in 1981, sends drawings to a manufacturer for them to start making the doohickey. And a month later, shows that to Texas Instruments. Texas Instruments is blown away, and a month later, or 3 weeks later, they confirm purchase order. In summer of 1981, meaning several months later, they reduced that thing to practice, meaning that they actually build the doohickey. And then in April of 1982, almost 9 months after the reduction to practice, they file a patent application. So we said that, we have a 1-year grace period for on sale bar, right? That is, once you start selling the thing, you have 1 year to file your patent application. So when we analyze on sale bar, we first figure out what the critical date is. What is the date before that the on sale bar attaches? And bar in this case, of course, is not where you go get a drink. Bar is the thing that prevents you from doing something. The application was filed on April 19th, 1982. So if they wanted to avoid on sale bar, the sale activity needed to have happened after April 19, 1981, within that 1 year grace period. But we see that hold on one second. Sorry, I realized just now I forgot to plug in my computer, and it's yeah. Are we there? Okay, sorry about that. I actually couldn't find the thing to plug it in, but we're ready to go. Okay, so 1981, April 19th. So what happened was that April 8th, Texas Instrument confirmed the oral purchase. But they didn't have the product yet. And they didn't have an actual sale. They only had a bunch of drawings, an offer to sell this thing, and an oral confirmation that, sure, when you build it, I'll buy it. Does this give rise to the on sale bar? So the court repeats what it was that we saw a couple of weeks ago when we were talking about Ethicon v. U.S. Surgical, that the primary meaning of the word invention in the Patent Act unquestionably refers to the inventor's conception rather than to a physical embodiment. The statute, the law that we have, Section 102, does not contain any express requirement that an invention must be reduced to practice before it can be patented, which is basically the same thing that the Ethicon court said, that conception is the formation in the mind of the inventor of a definite and permanent idea of the complete and operative invention as it is hereafter to be applied in practice. So just conceiving it, coming up with a thought of it, is considered a complete invention and does not require a reduction to practice. On 18, we see that why is that? Why do we require this thing? And it says the law identifies an interest in providing inventors with a definite standard for determining when a patent application must be filed. I actually think that the court is being generous to the patent applicants by saying that, because I think what the court is trying to say, the law identifies an interest of the public to obtain the information about the inventor's invention as soon as possible under definite standards. That's why we have that. And we'll get to that when we quote from the court later on. So the timeliness of an application depends on the date when an invention is substantially complete, undermines the interest in certainty. So basically, we need to have a completed invention, not a substantially complete, but a completed invention. That the word invention must refer to a concept that is complete rather than merely one that is substantially complete. This is basically the court going through all the cases and summarizing, including Ethicon, and summarizing that this is the law. We are reaffirming the fact that you don't need a reduction to practice, but you need to have a complete conception of the invention. So reduction to practice is a sufficient evidence of completion because you've reduced it to practice, but is not a necessary evidence for completion. We can show completion using other things than just reduction to practice. So now that we know at one point do we have an invention, then now we have to say, when does the on-sale bar attach to that invention? When does the on-sale bar attach to that completed conception of the invention? not the reduction to practice of the invention, but the completed conception of it. So first of all, the product must be the subject of a commercial offer for sale. Was this product subject of a commercial offer for sale? Yes. They showed it to Texas Instruments, and they said, we're going to sell this to you. And Texas Instruments said, fine, we're going to buy it from you. So it was the subject of a commercial offer for sale. What does the word commercial mean when we say commercial offer for sale? Do you guys want to venture a guess?
Maybe that
Can you?
it's not sold to a particular party, but just offered on the market for people to see that they want it.
I live in Utah. If I were to sell this to John, who lives in California, would that be a commercial offer for sale?
Does it matter where the seller and the buyer live? I mean,
if I raise that hypothetical, it means that it does matter.
okay.
Yes, Abby is
I'm
correct in the chat. Any commercial activity that can be regulated by Congress under the Constitution's Commerce Clause is a commercial. In law, when you say commercial, we're going to see that in trademarks when we have commercial use in commerce. Well, what does that mean, commercial? How can you have commercial use that's not in commerce? Well, if that commercial use is not being regulated by Congress, then it's not commercial use in commerce. In here, it's commercial offer for sale has to be something that's regulated by the Commerce Clause. So if I were to sell it to John, who is in California, because it's crossing state lines, it's subject to regulation by Congress. But if John was my neighbor, then no. So the invention must be ready for patenting. This is what was Pfaff's major contribution to patent law analysis. Ready for patenting. What does ready for patenting mean? This was the first time any court used that phrase, but nowadays all patent lawyers use that phrase. So by proof of reduction to practice before the critical date, it was ready for patenting. If you've reduced it to practice, we all know it's ready for patenting. But the second one is the important one. By proof that prior to the critical date, the inventor had prepared drawings or other descriptions of the invention that were sufficiently specific to enable a person skilled in the art to practice the invention. That is, we provided a description, a disclosure of our completed conception of the invention such that anyone who knows what's going on in that field can take our disclosure and reduce it to practice. How do we know this? How do we know that Pfaff's invention was ready for patenting when he had those drawings and showed those drawings to Texas Instruments? We know that because on slide 20, we see that when Pfaff accepted the purchase order, his invention was ready for patenting. Why? The fact that the manufacturer was able to produce the socket using his detailed drawings and specifications demonstrates this fact. So the same drawings that he showed to Texas Instruments that TI said, okay, I'll buy it, he showed the same drawings to the manufacturer, and manufacturer reduced it to practice simply by looking at the drawings. So the drawings were a complete conception of the invention, because an ordinary artisan could take that and reduce the invention to practice. So we talked about very, very quickly. Slide 21, we talked about you don't need actual reduction to practice. So what is actual reduction to practice? That means you make a physical embodiment of the invention. You make the doohickey. What is constructive reduction to practice? That's when you file a patent application that satisfies Section 112A. Section 112A will, I have it on slide 22. We won't get to it until after we're done with 103. But it says the specification shall contain a written description of the invention and the manner and process of making and using it in such full, clear, concise, and exact terms as to enable any person skilled in the art to make and use the same. So if your patent application can allow the ordinary artisan to make and use the invention, then your patent application that was filed is a constructive reduction to practice. The last slide, why do we have on the on sale bar? Well, because it discourages the removal from the public domain of inventions that the public reasonably has come to believe are freely available. So you can't introduce something to the market, get a whole bunch of market share, and then say, oops, it's patented now. You can't do that because the public has come to expect that this is not a patented product. The other thing is favoring the prompt and widespread disclosure of inventions. Basically, all patent law is designed for that, for you to provide as much detail as possible, as quickly as possible, because we're going to give you a monopoly. So in return, you have to do these things for us. You have to teach us what you're doing as quickly as possible. Then you have a year to see, hey, does this product have any leg or not before you spend any time and money on patenting it. So you basically can test market it for a year and then file your patent application. And then the last one is basically you don't want to expand the patent term. So for like 10 years, you're selling it because you're the first one to the market. And then on year 11, the competitors are coming in, you patent it. And then you say, so for the next 15, 16 years, you can't make it again. And so you have basically, in effect, extended your patent term to much longer than it should be. So you have 1 year, the same 1 year that we have for priority dates to file your patent application. So quickly get the product to the market and tell us what the product is. That concludes what I was going to talk about today, the on sale bar. So next week, we're going to continue our discussion of 102 because we're nowhere near going through all of it. Thanks for listening, and the floor is open for all sorts of questions and hopefully relevant answers. And please raise your hand if you want to come up.
Thank you, Sam. Wonderful room as always.
Thank you.
Quick question on the publishing part. So the first part of the what do you call it? The article. We spoke about publishing in a newspaper or making a poster or whatever. What about these days? Let's say you get an idea or you have a, what did you call it? A doohickey, and you explain it on YouTube or on TikTok, for example. Does that count?
Oh yes, absolutely. That's definitely publication. That's public disclosure. No two ways about it. The only thing there that can help you is that your YouTube disclosure was a non-enabling disclosure. That is, by looking at your YouTube thing, nobody knows what the invention is or
So
how to
so
make
if
it.
if I just use it on YouTube, that's a thing, and if I explain how to make it, that's a different thing.
Yes. Or, I mean, the thing is, you don't have to explain it. If by looking at it, it would be apparent how to use it, then there is an inherent disclosure of use. We'll talk about inherent disclosures next time. It's not explicitly said, but it's the necessary and always result of what it is that you're doing.
Yeah, I see. That makes sense. Thanks.
Sure.
We have a question in the chat. How long is it, by Abby, how long is it in the marketplace to be considered domain and too late to
Public.
file? Public
1
domain,
year.
yeah. What is it? What's reasonable time? What's a reasonable time that the
No.
courts apply?
Yeah, the courts don't apply this. This is in the statute. You have 1 year. It's in Section 102B. Today, we're just talking about Section 102A1. So next time, we're going to talk about Section 102A2. Then we're going to get to Section 102B1, then B2. So when we get to Section 102B, those are the exceptions to this on sale bar. You see that in Section 102A that we talked about, there is no 1 year limitation. That is in Section 102B. So we're going to see that the next time. That is by statute. You have 1 year. It's not a latches or anything like that. So Abby says, what happens if there are other laws governing the rollout of the product? Regiments of a testing period by a government entity overseeing that product, can that be excluded from the 1 year? The thing is that if you have not received governmental approval for your product to be on the market, it cannot be on sale. And so if you have offered that product for sale, and that product that you offered for sale is covered by the claims of your patent application, that product, is covered by the claims of the patent application, and you made that offer for sale before the 1 year, you still have the on sale bar, even though government regulations prevent you from actually coming into the market. Those are completely so the thing is, what happens at other agencies doesn't affect what happens in the patent office, and vice versa. They each basically follow their own protocols. The only way the FDA and the patent office intersect is when a drug is approved under the FDA, you can get an additional period of exclusivity on your patent. So you apply to the FDA for that, and then the FDA deals with the patent office to make that happen. But other than that, these agencies don't care what the other one is doing, because they have different standards. Hi, Victory. Why don't you? We're going to be talking about trademarks after we're done our discussion of patents and copyrights. So we can deal with your question there. And Pluto's coming up on the stage. I sent you an invite with the caveat that I still don't know anything about AI. Oh, okay. Let's see if he can come up now. All right. Hi, Plutos. I think he's having connection issues. Anybody else has any questions? You can raise your hand and come up on stage until Plutos figures his connection out.
I think it's working now,
Oh,
Sam.
yes, it is.
Oh, great. Okay, yeah, I had to leave and come back a couple of times. And oh, okay. Okay. So maybe one question is what statutory modification, if any, is like necessary to align the definition of disclosure in specifically like for defensive purposes, with with maybe the definition used to like trigger the novelty bar.
You know what I just realized was I forgot to include the very first case that basically tells you what novelty even is. How do you compare the claimed subject matter with the disclosure of the prior art? I'm so sorry about that. I completely escaped my mind. I just plowed into this. So maybe next time we will do that, and that would be the answer to your question. The thing is that, I mean, to kind of give it quickly, you basically list your claim elements. A claim element is basically, if you have a car has 4 tires, it has an engine, it has 4 doors. So the tires, engines, doors, those are claim elements. So you list your claim elements in a chart, and then you look for the equivalent of that in the disclosure. If there's a missing element in the disclosure, then it's not disclosing the claimed invention, because your claimed invention is different than the disclosure. There has to be a 1-to-1 correlation between all the elements in the claim and their disclosure. So the disclosure may have more things in it than your claim. That doesn't matter, as long as all the elements of the claim are in the disclosure. So that is the definition of novelty. Novelty means that not all claim limitations are disclosed in a single prior art reference.
Oh, okay, yeah, I'll have to look into that more. Yeah, I think I'll listen to the recording. But I think
I haven't talked about that. I'll thank you for reminding me. I'll go ahead and do that next time in greater detail.
Okay, and then another one is looking on the slides. Another one quotes is the presumption of accessibility. So should that like only apply like if the reference is like indexed by a verifiable public archive or search engine? You know, like other like external proof over internal metadata.
You always start with metadata, with what's in the patent application. And then if the examiner deems that to be insufficient, you have the opportunity to submit additional data. But the thing is that the file of a patent application is a closed universe in the patent office. So if anything needs to be considered, it has to be officially entered into the record. Otherwise, it's not going to get considered. Did that answer your question, or?
Yeah, I think so. Yeah, I'm just going over.
So I mean, the examiner can cite references and say what you're saying is BS. You're not. It doesn't make any sense because of this paper. And then you can cite contrary papers and say, yeah, I'm going to distinguish that one, but look at these other ones.
Okay, and what about the the inventor's successful retention of another term is technical control over the device, like remote monitoring, mandatory data return. Like, does that outweigh the commercial distribution of the necessary enabling documentation?
I'm not really sure what you're asking. If you could rephrase the question or explain more, that'd be great.
It was from I think the case testing the boundaries of Weber controlled distribution versus functional publication. You know, that with the ruling, I believe it negated the protective effect, right, of confidentiality clauses. So I'm not sure if I'm framing the question correctly. You know, okay, so the inventor's successful retention of the technology control, how does that, like, you know, like whether it be remote monitoring or does that outweigh the commercial distribution? Yeah, so I'm not sure if I'm framing the question correct or if it's even succinct enough.
Yeah, I'm not. I unfortunately, I can't follow the question. So,
Like how much, like how, you know, how
Do
much
you have
like
an example of something that maybe you could start with something more
yeah,
concrete before it's too
oh,
hypothetical?
okay, yeah, that's the okay, yeah. I think that's the correct case. The boundaries of Weber, how much, like patent council structure agreements, how much they you know with key like supply chain partners or alpha beta testers, like to maintain like the sufficient control and secrecy to avoid triggering that printed publication bar. Not is that clear enough, or I could be wrong here.
yeah. I'm because I didn't see where the printed publication part was. Where is it? Where is the printed publication?
Yeah, and I think I have the correct case too. I think it was last year. the Weber controlled distribution versus functional publication. Yeah, well, I may have to go back and look this up.
Versus who? Who's the other party? Weber control versus who?
Yeah, see, I have to look it up. That's probably what I'm missing. Well, sorry about that. This could be incomplete.
Yeah, so unfortunately I don't know what you're discussing sufficiently for me to be able to address that. Hi, David. Hi, Chinga. Welcome back. Do you guys have questions or comments?
I do.
Yes.
So forgive me. You're right. I'm a one-hit wonder. I apologize.
No, that's fine. It's a good hit.
So I remember when you started this series, you did say some of the history where this all came from. This came from UK customary and patent law and all that kind of stuff. But currently, where it sits, where is this stuff anchored? Is it anchored in the Constitution? Like where is it anchored at?
Yes, in the Constitution, in Article 1, Section 8, Clause 8.
Okay, and then that is in terms of international, those are agreed through reciprocity agreements or just sort of handshakes?
No, there are a bunch of treaties that the main part of it is the Patent Cooperation Treaty, and then an amendment to that is the 1995 Uruguay round of GATT, General Agreement on Tariffs and Trade. That also kind of added additional requirements internationally, and so the international procedure is governed by WIPO, World Intellectual Property Organization.
Okay. So if you're from England, say, and you have a beef with the United States, through these treaties and agreements, the U.S. would come to the table. But if the U.S. decides that whoever's the adjudicator decides something they don't like, if they wanted to be totally recalcitrant, they would just say, no, we're not going to abide by it. And then the things that ensue later would just be further trade disruption, right?
Yeah, so world trade, so the disputes over international patent agreements are adjudicated by the World Trade Organization.
Yeah.
So they do international trademarks and international patents. I think copyrights as well. So if you lose your WTO case and you don't abide by the terms of the decision, then you are in breach of your international treaty. And now you have to see what the consequences of that breach is in the agreement. It could be that you're then taken out, but then if we are taken out of the PCT scheme or WTO scheme, it's like that's the end of us.
Mm-hmm.
Yeah. Then we have no standing internationally anywhere to do anything. Because see, right now under WTO rules, an inventive activity done in one WTO member state is considered inventive activity in any WTO member state. So if you want to file a U.S. patent application, you have to be a U.S. inventor or a WTO member state citizen. So if we are taken out of that, then we cannot file applications internationally, and we cannot accept patent applications from international inventors.
Yeah, I was just trying to see how tenuous or how strong those consequences might be, because especially under Trump, the U.S. could just either bully, or they could rely on their economic advantage, or they could bribe somebody. I'm just wondering, because the with American Indian law, I'm not a lawyer, but my American Indian law for it, so like American Indian law is pretty much made up. It's not a real thing.
Yeah.
It's by the grace of the United States that it's allowed to exist, because it's not anchored anywhere. It's not anchored to the institution. The Constitution. It's not anchored to international or anything. It's just kind of floating around there on top of the U.S. federal law, and because there's no anchor, things like ICWA and all those kinds of things are just at the whim of Congress, right? And so, um,
Yeah,
I'm trying to figure out in the stuff that I do with genetics and other kinds of stuff that I do, I want to try and create that anchor. And if the US isn't going to constitutionally provide us that anchor, if we can provide that anchor somewhere internationally.
that's really complicated.
Yeah.
The short answer is probably no,
Mhm.
because you are a U.S. citizen and resident, so you gain access to the international scheme through the U.S. Patent Office.
Yeah, sort of.
Yeah.
So for the other Indian laws, it's again, it's floating in space, mostly because of the Marshall Trilogy, right? And Marshall Trilogy said, because tribes are domestic dependents, they're domestic dependent nations, and the Congress has plenary power on anything that has to do with Indian law. So, like I said, it's by the grace of Congress that the laws are allowed to function, exist for most things, except for can't remember right now. But yeah, anyway, I'm just looking at trying to find ways to anchor stuff in other jurisdictions, because the US probably won't, because they established the plenary power in whatever 1893.
Yeah, sorry. I don't know much about uh, Indian law or its interaction with federal law. I apologize.
No, you still help me. It's still helpful.
Okay,
Thank you.
sure. Hello, Bam. Welcome to the stage. Hi, David. David, are you ready to go?
Yeah, I have
All
a
right.
question. It's kind of a similar boundary condition. What about in national security secrets and agreements you might have? How do they interact with this? If you're developing a technology and there's a military use, do you get a knock on the door from them? Is it always going to be tangentially because you're using some spectrum that they control, or you're already governed by other laws? Um, and then how does it work with is it like what was it called? Like eminent domain? Do they just take it? How do property rights work with that?
So when you file your patent application, it is secret for 18 months, right? Within the first 2 or 3 months, the patent office reviews the subject matter of your invention. If they determine that it has nothing to do with national security, they will issue you a foreign filing license, meaning that you can now take this application and file a PCT, Patent Cooperation Treaty application, or file it in other countries. They may tell you this is basically under secrecy. They put a secrecy trying to, it's under the Secrecy Act, but they make it a secret. So basically and they don't give you, so the other thing is that they don't give you a foreign filing license, but you could still pursue it in the United States. And then the third one is they put slap a secrecy thing on it. If they do that, you go ahead and you get your patent, but that patent never publishes. Nobody will ever know that the patent exists. In the official Gazette of the Patent Office, where all the patents issue on Tuesdays. So in the Wednesday issue of the Gazette, they list all the patents that issued on Tuesday. For that patent number, in brackets, it says subject to the Secrecy Act. So you don't know what the title is. You just know that it exists. So but you do get your patent, but the commercialization of that, again, is going to be subject to the approval of the Director of National Intelligence.
And does that expire when there's technologies that become part of what do you call prior art? Because some things don't stay secret for forever, right? Can you maybe
The
describe some examples of that?
secrecy status is not automatically removed. That is, once the patent receives the secret status, if you want that to be removed, you have to file a petition with the patent office to remove. So you actually have to pursue the removal of the secrecy order. Otherwise, it just stays. Because the patent office doesn't want to go back through all these things and
They don't have
every
a duty.
year
I
do.
understand. So if you wanted to go do commercial things, you would after it looks apparently not so secret. What is the business case for not doing so? That they don't want to sell it,
Well, you
or it
first have
stays
to clear
secret?
it with the
DNI,
DNI.
right?
Yeah. You
But
first have to
I'm
clear with
saying
the DNI.
sufficient.
If
Let's
the
say
DNI
from
says
the
it's
80s.
okay, then you
Let's
file a
say night
petition
vision
with the
from
PTO.
the early 80s, like night vision. It's I'm sure there's certain things that are still under patent, but secrecy, but not everything that's sufficiently old.
Yeah, but the secrecy is sufficiently strong that countries like Iran can't make night vision goggles, right? They have to buy them from the West.
So you're saying that the manufacturer of something that's not quite obsolete, but clearly not state of the art, just anything in its chain of intellectual property would stay secret?
Yes.
Everything. Okay.
If the DNI determines that it is, or DIA determines that it is, then yes, it stays.
And
I'm sorry, you're done, David. I'm sorry.
real quick, last wrap up. And so, like in international, uh, there would be a French competitor that wouldn't come along and figure it out by reverse engineering it. How does I'm trying to figure out how do the international arms
Then
work
under a secrecy, under seal, you can submit that or a relevant summary of it, submitted to the Foreign Patent Office. So the foreign examiner sees it, but it doesn't enter into the record. It doesn't get disclosed to the applicant. And the patent office there just says, there is a secret prior art. And the guy says, so what does it say? And the examiner says, sorry. And so the person's SOL. You're not going to get your patent.
slow on hitting that mic. Mike, David, are you done? Your mic is closed if you're talking.
Yeah, go ahead. I'm sufficient.
Sam, I so appreciate you giving us your time on this stage. And ironically, I was having a conversation with a business associate regarding our IP attorney that's on sabbatical. He's been on sabbatical for a long time. And so we're looking for another firm. And so my question is, do you do quick consultations, say within 18-ish minutes? And 'cause it's just based on your bio, man, you're burning the candle at both ends. Do you have time for an up to 18-minute conversation?
I do, but not in this forum. Privately, yes.
DM'd you? Is that good enough for you to connect with me?
Yeah, just send kind of, what do they say? DM me. Just send a message through Clubhouse. Give me your email address, and then I'll contact you.
DM is you. That's typically referring to IG, which is Instagram. So
No. You know,
Voice
right
memos
here.
are accidentally
If you go to Instagram, I will never ever see it. Just you know how you message here in
The guys
Clubhouse
just
private
didn't figure it
message. Clubhouse private message.
I'm
yeah.
complete.
Thank you.
Cheers, bro.
Okay. Any other questions? Well, appears there are no more questions. So I'm going to say goodbye and remind you, Thursday is our chemistry room at 2:00 Mountain Time, 1 Pacific, 4 Eastern. And then Thursday, John will have his bite of physics, 9:30 Pacific,
Friday, you mean?
12:30 Eastern. Friday.